Hello guys, nagbabalik ulit tayo. Nandito pa rin tayo sa history. Okay, we proceed. In later years, these assemblies referred to as elastic courts become courts of first resort, presided over by judges who prepared cases for trial. The elastic courts consequently became widely, and they were divided into sections called dicasteries. Pagdating, eto guys, kung mababalikan natin dito sa Athens guys, 'di ba? Nagkaroon na kasi ng public assembly na tinatawag na kung saan makaka-attend yung lahat ng maraming tao para masaksihan yung proceedings na tinatawag guys. Kaya pagkalipas ng maraming panahon, ito na yung pinagbasihan ng first resort ng court guys ng mga tao doon. Tinawag nitong elastic court guys. Kaya yun, nagkaroon din ng tamang division pagdating sa courts. Kumbaga nagkaroon guys ng pagbabago. The evolution of courts in ancient Rome was evident by the development of complex structure in which criminal and civil or other jurisdictions were differentiated and were exercised by separate courts and official yan. Ito guys, nagkaroon na ng proseso na tinatawag o pagbabago, the evolution of court guys, pagdating sa ancient Rome. Yan, nagkaroon na ng iba't ibang jurisdiction kung ano ba talagang may hawak sa isang lugar para magkaroon ng proper trial na tinatawag natin guys. Violation of criminal law were prosecuted by the state of higher and lower courts were organized. The right of appeal was judicially assured and a corps professional juries was established for the first time in the history of Mediterranean civilization. Yan guys, nagkaroon ng pagbabago pagdating sa katulad nga ng paulit yung sinabi guys, nagkaroon na ng pagbabago pagdating sa court proceeding dito sa time ni Mediterranean civilization. Ito yung mga first history na nagkaroon talaga ng tamang proseso pagdating sa mga akusado o may mga kasalanan sa batas. Okay, we proceed. After Christianity became the state religion of Rome, the ecclesiastical courts, established by Christians who had refused to have recourse to pagan courts, become a part of Roman legal system. As the Roman Empire disintegrated, the ecclesiastical courts survived and assumed jurisdiction over secular affairs. Yan. Pagkatapos na ng Christianity, yung isang religion guys to, no? Pagkatapos ng Christianity guys, yan, pumasok na yung itong courts na to, na in-establish ng mga Christian guys. Ito yung pinagbabasihan nila pagdating sa batas. Yan, the Roman legal system. Yan. Medieval courts were consequences of the tribal courts of the Germanic people, among whom the highest judicial authority was that of popular assemblies that met regularly throughout the year. The tribal magistrate supervised the proceeding and executed the judgment rendered by the assemblies. During the progress of Germanic tribal organization into territorial states, the primitive and tribal courts underwent a corresponding evolution, increasing a number and becoming differentiated. Among the new qualities of this Teutonic system were royal courts presided over by the king and patterned after the Roman system of courts, special lower courts under the control of royal officials who were called Grafen, which handled minor matters, and later corps of permanent lay judge were with power to render judgment. Ito guys, sa medieval courts na tinatawag nito, marami ng iba't ibang uri ng courts na pumasok, di ba guys? Dito, sa panahon na to, kumbaga meron ng mga humahawak. Pagdating sa atin, kung dito sa panahon natin, di ba, may MTC na RTC, Court of Appeals, Supreme Court, Sharia Court, Sandigan Bayan. Dito guys, yan. Dito pagdating sa Roman system, nagkaroon na sila ng mga pinagbabasihan pagdating sa pag-execute o pagbibigay ng final judgment sa isang akusado. Medyo mahaba kasi. In the 8th century, when the Germanic territorial state were part of the realm of Charlemagne, the Teutonic judicial system experienced a further momentous development, the practice of initiated by the Charlemagne of the dispatching royal commissioner to examine the functioning of local courts and were necessary to supplement the justice they dispense. In this improvement were the seeds of three later important legal development: assize court, circuit courts, and a central legal authority. Yan guys, dito sa pagdating sa 8th century ng Germanic territorial state, ay nagkaroon na ng pagbabago talaga guys. Meron na silang courts, circuit courts, and central legal authority. Kumbaga centralized na guys. Kung ano yung isang batas na pinagbabasihan sa isang lugar, eh dapat ganun din yung pagbabasihan sa ibang lugar. Kasi hindi dapat chop suey na tinatawag guys. Kaya nga sila ay nag-dispatch ng Royal Commissioner na mag-i-examine sa mga local courts kung tama ba yung binibigay nilang o tama ba yung supplement na justice sa iba't ibang function ito. Okay? A significant innovation during the reign of Edward I was provision for doing justice in the situation in which the common law failed to afford remedy to aggrieved litigants. This supplemental procedure of justice was administered by the Crown through the Lord of Chancellor and was called Chancery of Equity Jurisprudence. Kung mapapansin nyo guys, ito mga monarchy na to, diba? Edward I, yung mga king yan. Yan guys. Dito guys, may nag-fail daw sila pagdating sa pagbibigay ng tamang justice. Kaya, ganyan, nagbigay sila ng supplemental procedure of justice guys. Headed by the Crown of or the Lord Chancellor guys, kung saan dito pinabase na yung tamang procedure o jurisprudence na pwedeng ibigay sa isang akusado. In the centuries after the signing of Magna Carta, Parliament attained appellate jurisdiction over both civil and criminal cases. This function was subsequently confined to the House of Lords and has survived to the present day. In 1701, Parliament enacted legislation establishing tenure of office for judge and made the removal from office conditional or the concurrence Parliament, thus completing the separation of judicial from executive, legislative, governmental powers. Ito guys, pinag-iwalay na yung dito. Pagdating sa time na to, diba, iba-iba naman talaga dapat. Kung ano yung executive branch, legislative branch, dapat iba-iba din yung mga sangay ng gobyerno nila. Because of na Magna Carta, sa minirmahan nila dito guys, yung parliament na tinatawag o yung kapangyarihan ng isang state, ay iniiba na. Iba yung kaso sa civil, iba din yung kaso sa criminal case. Yung mga function na tinatawag natin dito, ay talagang nagkakaroon na ng evolution na tinatawag natin. Nag-establishment na sila kung ano ba yung pwedeng humawak. Yan, nagbigay na sila ng judge dito at ibang-ibang uri ng pamamaraan upang mas iayos yung kanilang court system. In France, the development of the judicial system after the breakup of the Carolingian Empire was comparable to that in England. Both involved the vesting of central legal authority in the crown after the prolonged struggle with feudal manorial courts. The basic feature of judicial system now in effect in France were established after the French Revolution of 1789 by the Code of Napoleon. This system consists of lower courts of the wide jurisdiction, intermediate courts of appeal, a court to resolve your jurisdiction conflicts among courts, and supreme appellate tribunal called the Court of Cassation. Many European, Latin American judicial systems are patterned on that of France. Yan guys. Yung France, ito guys, because of the breakup of Carolingian Empire, nagkaroon na talaga sila ng central legal authority na tinatawag natin. Yung nagkaroon na sila ng tamang criminal justice system dito na pinagbasihan ng iba't ibang bansa din, katulad ng European and Latin American. Ito yung pinagbasihan nila ng judicial system, kung ano ba yung dapat na ipatupad, di ba? Kasi dito guys, nagkaroon na ng lower courts, wide jurisdiction, intermediate courts of appeal, a court of to resolve jurisdiction, conflicts among courts, and supreme appellate tribunal called the Court of Cassation. Yan. Nagkaroon na kasi ng ganito guys, kaya ayun ang pinagbasihan ng yung ibang bansa. Di ba? Para iisa lang yung judicial system nila. At tama yung pagbabasihan nila. In the Islamic word of the Quran is the source of law, justice, and traditional has been dispensed by specially trained priests in conjunction with the king of or sultan. Yan guys. Pagdating naman sa mga Islam guys, yung pinaniniwalaan nila yung Quran. Ito yung pinaka-korte nila guys. Dito sila nagbabase. In the 20th century, this system still exists in such Islamic countries as Yemen and Saudi Arabia and Turkey. However, executive, legislative, and judicial function have been separated and judicial system similar to those Western country has developed. Yan guys. Pagdating naman sa 20th century guys, ito pa rin yung pinagbabasihan nila, yung Quran, yung patag ng mga Islamic, lalong-lalo na especially yung Yemen and Saudi. Pero pagdating dun guys sa legislative na tinatawag natin, the judicial, ay iba-iba na yung naging separated guys, hindi na basta-basta pinagbabasihan. Tapos yung judicial system, similar to those western na, yan, parang meron na silang pinagbabasihan din. In the other Middle Eastern and Asian countries that have attained independence since World War II, notably Sri Lanka, India, Israel, the courts also function similarity to those the West. That is relatively independent within parliament framework. Yung parliament framework na tinatawag natin guys, ito yung mga namumuno. Yung parliament kasi karaniwan ang namumuno dito, yung mga hari pa rin. Pero meron pa rin silang kumbaga kumukuha pa rin sila ng idea pagdating sa Middle Eastern and Asian countries, guys. In communist countries, the judicial system was usually patterned up that of the USSR, which integrated the hierarchy of courts culminating as Supreme Courts. In the former Yugoslavia, all judges, even those of the highest tribunal, were elected, not appointed yan. Tama naman guys, diba? Yun sa, dito guys, sa judges pala, hindi ina-appoint guys, elected, kumbaga pinagbubutuhan. Dito kasi sa judges natin, alam ko, ina-appoint yan. Kung ano ba talaga, kung nararapat ba siya sa isang pwesto. Dito naman, sa communist party na tinatawag natin, o communist country, like ano guys, like, yung mga komunista guys, yung North Korea, di ba? Ina-appoint daw yan guys. Not appointed, pero elected. In the Philippine judicial power, which is vested in Supreme Court, Court of Appeals, regional trial courts, and such other inferior court as may be established by the law includes the following. Yan. Ito yung iba't ibang uri ng judicial system natin, guys. Number 1, to pass upon the validity, constitutional, of the law of the state and the acts of the other branches and the Department of Government. To interpret and construe them. To render authoritative judgment, and it also includes the incidental powers necessary to the effective discharge of the judicial function, such as the power to punish person adjudged in contempt and issue warrant of arrest after due process has been observed. Yan guys, ito yung mga paraan natin pagdating natin sa pagbibigay ng hustisya sa mga akusado na tinatawag natin guys, para patas, di ba? Pero ito, pinagbasihan din natin to sa Philippine Constitution natin guys, sa 1987 Philippine Constitution, di ba? Ito yung iba't ibang uri natin guys. Court en banc refers to meeting of all judge of the court, usually purpose of hearing, arguments, demurrers, motion for new trial, and reviews. Ito, court en banc guys. Dito nagmi-meeting yung mga judges. Dito pinagbabasihan o nagkaaroon talaga ng hearing. Argument guys, pagdating sa kaso. Demurrers na tinatawag natin guys. Ito yung pagpapalitan ng salitaan. Motion for new trial. Tapos review sa kaso guys, kung dapat bang ituloy yung isang kaso o hindi. Court of General Jurisdiction refers to a court with unlimited trial jurisdiction, both civil and criminal, but its judgment is subject to review by appellate courts yan. Yun sa general jurisdiction na tinatawag natin guys, unlimited trial jurisdiction, both civil and criminal. Ito, hawak nila guys, yung both civil and criminal. Pero yung judgment na tinatawag natin guys, i-review pa rin yan ng appellate courts kapag nagkaroon na ng hatol. Court of Limited Jurisdiction, in which court only assume jurisdiction on certain types of matters such as juvenile courts and family courts. Ito guys, ito kasi guys, kapag mga sensitibong bagay na, like yung mga juvenile na court natin, tapos family court natin, dito na kasi papasok ang batas natin na 9344 o Juvenile Justice Welfare Act, na kung saan pinoprotektahan yung custody ng isang bata o isang pamilya para maging maayos. Kaya nga limited jurisdiction siya guys. Hindi basta-basta certain types lang ng hinahawakan nila, yung mga masisailang kaso. Court of Original Jurisdiction refers to courts where an action is heard initiated in first instance. Yan. Yung original jurisdiction guys, dito yung for the word itself, first instance guys, kung saan unang tumapak o saan kayo unang nagkaroon ng hearing o proper procedure. Ito yung Court of Original Jurisdiction natin. Kumbaga dito unang pinapakinggan yung bawat panig ng dalawang grupo.